In the matter of K. Ramaswamy versus R. NALLAMMAL, Supreme Court allowed the appeal and remarked that we are of the clear opinion that the impugned judgment was not on good grounds and the cost awarded and directions for expeditious consideration would not unsettle the imbalance which would be caused to the plaintiff who had been waiting to get possession of the property for one last decade. Court also said that we are unable to accept the reasoning of impugned order to condone the delay because there was a falsity writ large in the submission of the lawyer having misplaced the files. In this case, an ex parte judgment and decree dated 13 April 2016 for specific performance was sought to be set aside by application dated 4 January 2020 after condoning delay of 1312 days long after legal representatives of first defendant appeared in execution petition filed by the plaintiff. Impugned order referred to two decisions of court in collector land acquisition Anantnag and another versus MST Katiji and others and H. Dohil Construction Company Limited versus Nahar Exports, both on the issue of condonation of delay and applied the principles of former to condone the delay and allow application, setting aside ex parte decree on payment of cost of rupees 1 lakh and a further direction to file written statement within 4 weeks. The suit was also directed to be disposed of within 3 months from receipt of order. Reasoning for exercise of such equitable jurisdiction was on the ground that predecessor or in interest who was the defendant in the suit and who had also half interest in the property, though had appeared before trial court, had not warranted a written statement and later died, upon which the wife and son, legal representatives, came into the picture. The contention of the counsel was that who was handling the case on behalf of deceased had taken time to hand over the files, which were misplaced. Eventually handed over the files on 16 December 2019, soon after the petition to set aside ex parte decree was filed, found favor with learned single judge. The High Court reversed the detailed order of trial court, which refused to condone the delay on the facts coming out from records. In MST Katiji, this court deprecated a pedantic approach in seeking for explanation for every day's delay and exhorted the doctrine to be applied in a rational, commonsensical, and pragmatic manner. It was also held that substantial justice and technical considerations pitted against each other, former should be preferred, especially in cases of non deliberate delay, which cannot result in injustice being done. Even going by said decision, the court said we cannot find a non deliberate delay in above matter, as we already found there is no explanation for deceased first defendant to have not contested the matter, the joint ownership with other defendant and power of attorney executed in his favor, as also sale agreement being admitted. If in fact the power of attorney was cancelled as pleaded, then it should have made defendant more alert in contesting the suit in which he appeared. The suit for specific performance filed in his lifetime was left uncontested despite the appearance. Death of the first defendant was long after the decree. The legal representatives, though claimed to be unaware of decree, was made aware when a notice of execution proceeding was served upon them. They appeared in execution court and neither contested it nor filed an application for it to be set aside for the decree for long. A frivolous contention has been raised that the lawyer took time to return the files, which contention is also a bland statement made without the date on which they approached the lawyer being specified. A specific question was put to the defendant who was examined on oath in support of application to set aside ex parte decree as to same lawyer having been engaged by his mother, which was not denied. Application to set aside ex parte decree was only afterthought and purely experimental. The law favors the diligent and not the indolent, said Supreme Court, while restoring order of trial court, rejecting the application for condemnation of delay.